Now I made it. Sorry about that. Yeah, thank you very much. After a few hassles and fights with the software, thank you very much for joining the webinar today. I'm very pleased and honored to present Jane List and Maurits Dollmann, with whom I worked together for 1 year on a project around standard essential patents in the UK and around specific issues from a competition perspective and from a valuation perspective. I must say I felt very privileged and honored to work with such a distinguished team, with Jane List as the editor of World Patent Information, who brought in a wealth of knowledge and background from her work in the area of patent information and patent intelligence, and Maurits Dollmann from Cleary, Gottlieb and Hamilton, who brings decades of experience in the competition space to the table and who's extremely knowledgeable on competition law issues around FRAND and other aspects, obviously, in Europe and the United States and in Asia. The webinar we are presenting here today is presents the work that we did and the research papers that were published with World Patent Information. They are still available until the end of the year, I think, for free online. And with this super brief introduction, I'd like to pass the floor to Jane to introduce the session. And Jane and Maud, thank you very much for working with me on this for 1 full year.
Thank you, Roya. My honour to work with you and Maurits indeed. Can you enable video sharing for me?
Wouldn't you not just have to simply...
It says host is disabled.
Okay, look, I'll make you the host, then you should be able to do that.
Okay,
yes.
Super. Oh. Super, thanks very much. Thank you, Roya. So I'm deeply honoured to be here with you today to moderate this session with Maurits Dollmann and Roya Gaffelli, who has been working together since around 2020, when the UK Supreme Court judgment was due out on the Unwired Planet and Huawei decision. And Roya, as on the editorial advisory board of World Patent Information, proposed this idea to me that we do something around this. And the issues of standard essential patents and how standards and patents interact in the IP ecosystem is something that has been bubbling as having potential issues and an ecosystem that perhaps needs some tweaking for some time for various different reasons. So I was very excited at this possibility and very delighted that we have these 2 papers published in World Patent Information. In case people who are on the seminar are not familiar with World Patent Information, I'll just do a slight sales pitch. We do publish papers on IP management, IP analysis, and IP education, and look at best practice in commercial and legal practice and patent prosecution. So all of those things that are underpinning the issues here surrounding the judgment from the UK Supreme Court. The UK IPO have also published in August this year their consultation, where there are very, very many conflicts of views and different stakeholders interested in the in what could happen, what could be improved with the whole standard essential patents, licensing and FRAND issues. Transparency is something that's also of concern, particularly to those of us in patent information profession, the interests of third parties to be able to find out about the existence of standard essential patents. But that's another matter. Today we're here primarily to discuss the papers, and for Maurits and Roya to present their work and to have some discussions around that. So first of all, Maurits, I would like to ask you please to present to us and talk about your paper, your views on the FRAND licensing commitments, with particular reference to the UK Supreme Court decision and with the ETSI. So could you start, Moritz, by telling us what's right and what's wrong, in your opinion, with the Unwired Planet judgment?
Thank you. To start, what's wrong with the camera is it doesn't see me, but then nobody wants to see me, so it's probably best if you just hear me. So it looks like the UK courts will continue to play a significant role as a forum for resolution of FRAND disputes. So the UK judgment in Huawei Unwired Planet really deserves close attention. Now, you will all remember that Unwired Planet is a patent assertion entity. It bought CEPs from Ericsson and then sued Huawei. Huawei was ready to take a FRAND license to the UK patents, but it resisted the idea that the UK court would set the rates for the whole world. But Mr. Justice Burse, as he then was, he did it anyway. He set the rates and he issued an injunction against Huawei to be enforced so long as Huawei refused to agree to this worldwide license. In other words, a conditional FRAND injunction, which is called a FRAND injunction. Huawei appealed and the UK Supreme Court confirmed. So let's discuss the good, the bad, and the affirmatively ugly. What's good is that obviously the judgment is well reasoned overall, beautifully written, and welcome on a number of issues. The idea of a FRAND injunction with the court setting a royalty is a good thing in itself. It's much better than the situation in Germany, where injunctions are issued without rate setting and without even looking at the CEP owner's offer. So you have a dramatically asymmetric situation in Germany. It's an ultimatum game. The CEP owner can get what it wants, so long as it's less than the implementer's total profits. And the German courts don't look at the royalty level. At least in the UK, both parties know in advance that if they don't agree, the courts will set the rate for them instead of just giving free rein to the CEP owner. Now, the Court of Appeals in Apple v. Optis is following the same approach. Neither of the parties, the plaintiff and the defendant, may like the prospect of the court setting the rate, but it means therefore that the best alternative for a negotiated agreement is worse for both parties than settling the case. And so they have an incentive to come to an agreement, and that system may eventually reduce litigation and encourage negotiations. Germany should take note. This is where the UK leads. Second, it's important that the UK Supreme Court recognized proportionality. Again, the German courts take note because they generally ignore proportionality, even though it's required both by competition law and by the IPR enforcement directive. And proportionality is particularly important in cases like Unwired Planet, where patent assertion entities are the plaintiffs. CEP owners tend to split portfolio and sell them off to privateers or patent assertion entities because small packages of patents are worth more separately than as part of a large portfolio. It's almost a law of diminishing return. And so this creates an incentive to split portfolios up into small bits and sell them off to independent patent assertion entities. But doing that leads to patent stacking because each owner, each new assertion entity sets the rate independently of what the others charge. And the result is a prohibitive royalty stack. In addition, these patent assertion entities are immune from counterclaims, which preserve their market power. Now, the UK Supreme Court actually mentioned this. They talked about the situation where the patented invention is only a small component of a big product, and the threat of injunction is employed simply for undue leverage in negotiations. And in such a case, the damages may well be sufficient, and an injunction is not necessary. Now, in Unwired Planet's case, the FRAND injunction is proportionate because the implementer has, and Huawei in this case, had the opportunity to escape the injunction by paying the FRAND rate set by the court. So that's good. Now, what's bad? Two things come to mind. First, it's kind of understandable that an English court would set a worldwide rate because it's common practice for these portfolios to be licensed worldwide, and country by country litigation is really impractical. I've tried it, it's a royal headache. Nonetheless, it creates problems where the implementers are prepared to take a UK-wide FRAND license. It's very hard to reconcile this approach with comity. It sets a bad example. Take it like this. If the English courts do it, the Chinese and other courts can set worldwide rates as well. And they do. And this creates a risk that different courts with jurisdiction over the parties and the subject matter come to conflicting conclusions for the same worldwide license. Now, combine this problem with worldwide rate setting with anti-suit injunctions, and we have a real problem. The Chinese courts have taken to setting rates worldwide and denying non-Chinese parties from asking courts outside China to set rates for their countries. So it almost looks like the UK Supreme Court released an uncontrollable force, a kind of golem. The EU is very worried about this and has submitted this question to the WTO. Now, there are ways to mitigate the problem. FRAND injunctions can make exceptions to cover the eventuality that another court sets a different rate for a territory with which it is more closely connected. And for instance, a UK FRAND injunction could set a worldwide rate and then said, but if the EU courts, or let's say the French court set a different rate for France, or the US court set a different rate for the US, then that rate applies. That would be a gesture of comity. And the Chinese do the same, but they don't yet, as far as I understand. So keep an eye out for the UK Interdigital de novo case, which is going to discuss this issue. And a related problem is that worldwide rates assume that the non-UK patents are valid and infringed. And this is a problem you can't even challenge in a UK court, because UK courts only look at UK patents. So, and often more than half of steps in the portfolio turn out to be invalid or not infringed. Now, you can mitigate that too by setting a rate that reflects a discount for the risk of invalidity, and then allows royalty adjustment in the case that an individual patent is found invalid. So this is bad, but there's a problem. The second bad thing is that the UK Supreme Court decided not to follow the Huawei ZTE process for negotiations. You may remember that this process starts with a verification whether the SEP owner, the one who gave the FRAND promise, has made a FRAND offer. And the UK Supreme Court said that, okay, if you follow that process, the Huawei dance, we call it, you're in a safe harbor. If you don't, you're at sea, but your boat doesn't necessarily sink. And in the UK, this is not so much of a problem because the court will set the rate for you. But in Germany, this really creates problems. Because imagine, first of all, you have bifurcation. The validity of the patent is set in a different court in a different proceeding than the infringement. So you can actually get an injunction on a patent that later turns out to be invalid. And then German courts issue those injunctions without even looking at whether the owner has issued a FRAND promise. And they do that without setting a rate and without reviewing whether an injunction is proportionate. So that leaves implementers at the complete mercy of SEP owners. It's an ultimatum game. The SEP owners can effectively ask for the entire profit of the implementer minus £1. Now, again, the effect of this is limited in the UK because the courts in the UK, at least, will set the validity and infringement, and they will set a rate. So Germany, take note, this is where the UK does it much better. Now, what is affirmatively ugly? That was the third thing, right? The UK Supreme Court reasoning on non-discrimination in FRAND is incomprehensible to me. It said that non-discrimination is not a separate requirement of a FRAND promise. So long as Unwired Planet's rate was fair and didn't exceed a single royalty price list available to all, it could charge Huawei more than Samsung, for instance. To me, that flies in the face of the wording of the ETSI IPR policy. It says, after all, explicitly that non-discrimination is a separate component in addition to the fair and reasonable licensing. And if you go and look at the history of the IPR policy, that's actually borne out. Now, the UK Supreme Court did look at some of the history. They said, well, there were negotiations as to whether non-discrimination was a most favored nation clause, and it wasn't. So I conclude from that if a SEP owner gives a rate to a first licensee and then a lower rate to the second licensee, it doesn't have to go back to the first licensee and give the first licensee a better rate as well. But the concept of non-discrimination is certainly deprived of all meanings if a SEP owner can charge a subsequent licensee a higher rate than a previous one. So there you have it, the good, the bad, and the ugly from my perspective.
Well, thank you, Moritz. So you've outlined some of the issues. So why do you think the judgment went wrong?
Well, I think the root cause was that the court ignored competition law. This was a real surprise to me. So the court looks at French contract law, and that's fine because the ETSI-RPR policy is governed by French contract law. But French law says you have to interpret the FRAND promise in the light of the context and the intentions of the parties. And both the content and the intentions was to solve a competition law problem, a policy problem. And so remember that in a standard setting, industry gets together to pick one technology over competing ones. And they do that by agreement. So Article 101 is at stake. And once an industry has agreed to the standard, and especially after the implementers have implemented it, industry is locked in. So that gives SEP owners market power. And they can use that market power by withholding a license and getting an injunction. And the injunction punishes the implementer by depriving it of implementation profits and a kind of hold up. It's an ultimatum game. And so this results in high royalties that are much higher than the incremental value over the next best alternative before the standard was set. And I say that very slowly because that's the proper criterion on the competition law for what is a fair and reasonable value for a patent. And this is even worse when ownership of the patents is fragmented, because you have a whole bunch of SEP owners with market power, all seeking a high rate, regardless of what other people ask. So it's that competition problem, an agreement between competitors creating market power, that the FRAND promise was supposed to fix. So it's not for nothing that FRAND, fair, reasonable, and non-discriminatory, mirrors the limbs of Article 102 of the treaty, right? Robert Porknell and Dave Javahirian wrote a very interesting article on the history of the RPR policy. And every document they looked at leads to the conclusion that FRAND licensing, and I quote, was expressly developed and adopted so as to promote and implement rather than replace competition law. And Professor Jorge Contreras comes to the same conclusion. And I remember it well because I was there. I remember the debate in 1990 about the green paper on standard setting and the 1992 communication on IPR and standardization. Competition law was all over the place. It's incomprehensible to me why the Supreme Court ignored this. Perhaps they wanted to avoid a reference to the European Court of Justice just before Brexit. Maybe I can't find any other explanation. Now, if they had followed competition law, then they would have interpreted the discrimination issue properly, because SEP owners are essential facility owners generally. They're not allowed to discriminate, not even in favor of their own affiliates, and not without objective justification. And yet the Supreme Court completely ignored this.
So thank you, Moritz. That's an interesting summary. So given that, what are the implications, do you think, now?
Well, apart from the discrimination issue, which is a serious issue, I also think that the royalty might have been fixed differently had competition law been properly taken into account. So as it was, Mr. Justice Burr says he then followed two steps. And I should add that this particular point was not before the Supreme Court, so we should keep that in mind. But he did two steps. First, he applied a comparable license method. So he picked a number of license agreements, looked at the rates, and then he compared them and then adjusted the rate to reflect the share that the unwired patent portfolio represented of Ericsson's entire portfolio before it was sold off. But one thing he did is he excluded one of those agreements from the comparison, the Samsung agreement, and I'll come back to that. And he then did a backup, a cross-check, a top-down method to avoid excessive royalty stack. He did that by determining the total royalty stack that would result if all other patent owners charged the same per patent as Ericsson had, or Unwired Planet. And he found that it was more than the patent than what the market expected based on Ericsson's own statements. That's an excellent summary there. So he found that actually the cross checks suggested that the rate was too high, and then he proceeded to ignore that. So I think that approach is open to criticism. And because competition law was in the mind of the ETSI members when they set the IPR policy, the rules on excessive pricing should have informed the contract interpretation of a FRAND undertaking. And that means that a fair royalty rate should reflect only the ex ante incremental value of the licensed technology over the next best alternative. It should not be based on comparators because they reflect the ex post value after the standard was set. And in particular, it includes license agreements that were signed under threat of injunctions. So that's circular reasoning. Because those original patents agreements were signed under threat of injunctions, if you then use those as benchmarks, then the result is going to be too high as well. It's circular reasoning. So it was also done inconsistently because the judge excluded the Samsung 2016 license because it was a fire sale, and he said, okay, that's an exceptional circumstance. But if he does that, why did he not also exclude the licenses that were signed under threat of injunction? Because that's also that's power on the other side. And I think he should have applied the top-down method in the first place. There was good information from Ericsson itself on what the industry expected and what Ericsson promised in 2008 to 2010 about the total royalty stack. And he should have followed that approach. I thought in the end it's very thoughtful and thorough, but not very satisfactory.
So what do you think could be done to improve?
Well, I think the IPO is reviewing its policy on steps and innovation. This is a very important review. And I would invite the IPO to reiterate the importance of competition policy and the essential facility doctrine as a basis for FRAND licensing of steps. And it can do that without contradicting the UK Supreme Court. Obviously, it's a Supreme Court, right? So they can't contradict the Supreme Court. And they can do that by calling on the courts to apply competition law as a matter of public policy in all FRAND cases in parallel to the contractual FRAND promise. So that the court would always have to look at two things: the FRAND promise as interpreted by the Supreme Court, and then separately competition law. And that would avoid the UK's Supreme Court's misinterpretation of the non-discrimination limb of the FRAND undertaking. And this is important because these FRAND abuse cases continue. Even yesterday, there was a press release about a complainant, HMD, who makes Nokia branded phones, about patent stuffing in a standard called EVS. It's a kind of audio codec. And that case concerned a situation where a bunch of competitors got together. They lost the competition for a standard, and then they thought, okay, let's go together and resubmit the proposal, and they stuffed that proposal with their patents. And then telecoms companies unthinkingly kind of make that standard mandatory, even though they actually don't support it in their networks. And then the SEP owners set up a patent assertion company which demands excessive royalties using German injunctions as a cudgel. And even worse, that standard doesn't actually add any value because it doesn't improve the consumer experience, and there are royalty-free alternatives. So this to me looks like a royalty ambush, just a tool to milk implementers. And it's very hard to see how contract law, like the Supreme Court used in Huawei and Wired Planet, could fix this. We need competition law for this. Thank you.
Thank you, Moritz. So it also sounds as if we need some kind of external body to check the validity of the patents that are going into the standards, no?
That is something which the European Commission is considering. Actually, often this already happens because many of these patents are licensed through pools. And when a pool is formed, the pool administrator has to check the patents to ensure that they are complementary and not substitutable. And so that kind of situation where people check patents is already happening. So it could be improved. I think this doesn't completely solve the problem that I identify, but it would help.
Thank you. Roya, do you want to take any questions from the listeners, the people who have tuned in, or go straight to your piece? Yeah, okay.
There currently are no questions.
Okay, super. So, I mean, anyone has questions, we'll do those at the end. So thank you very much, Moritz. That was really interesting overview and in-depth analysis of what has been done and what could be done. And now take a different view of the same case and to extend that, Roya, okay.
There's a question from Sharon Kommer from Queen Emmanuel saying, interesting that you think competition law will be the savior of implementers. German courts focus on competition law and ignore the contractual promises contained in a FRAND declaration. As you mentioned, the stance of the German courts seems to be much stricter on implementers than the ones of the UK courts.
So if only the German courts actually focused on competition law. I'm afraid I don't agree with you, Jerome. Nice to hear from you, by the way, that German courts properly look at competition law. Yes, there is the Orange Book judgment, and yes, on occasion they mention competition law and pay lip service to it. But what they ignore are the excessive pricing issues. They ignore Huawei ZTE, which is itself based on competition law. If you go to German courts, the court will just the Huawei ZTE dance. Usually, one of the first steps is that the SEP owner has to show that it makes a FRAND promise and it has a FRAND offer, and it has to actually justify and explain that. Then the implementer has to make a counter offer, which is SEP. If they then come to an agreement, fine. But that the German courts turn it around. They ignore what the SEP owner has offered. It goes immediately to what the implementer offers. And often in these negotiations, you start somewhat away from each other. They then immediately say, oh, that's not FRAND, and bang, injunction. No proportionality review, no excessive pricing review, no discrimination review, and no not following the Huawei ZTE. So I'm afraid I disagree with the suggestion that the German courts properly follow competition law. And indeed, it would be great if in that HMD case, the Commission made a reference for preliminary ruling to the European Court of Justice to assess precisely this point.
Okay, thank you.
Maybe let's just a short disclaimer what I just realized. I think Maurits's thoughts are very interesting. I'd just like to make the disclaimer that they're not necessarily the thoughts of myself, of Jane, of WPI, of OxFirst, any of OxFirst affiliates, or anyone else I can really think of. Just to be clear, to not put it on in my court.
No.
Well, thank you, Roya, and yeah, indeed, that's why we're here, to encourage debate and discussion, and
yes.
and have a number of different views shared. So, Roya, could you kindly share your
yes.
views and analysis of the valuation perspective? Thank you.
Jane and Maurits, thank you very much. Very, very super interesting. So my thinking on this whole question was a bit more very differentiated and very to the point and very nuanced. And we were chasing up the big question of proportionality of injunctions, and if we can find any economic evidence, because I think right now this notion is a bit out there in the sky, and we haven't got really numbers behind it. We haven't been properly defining it. It's sort of like a sense of why it could be or it could be not, but we were trying to get closer to pinning this down from an economic perspective. So my analysis pertains not to the entire case or to all of the stuff that happened. Unlike Planet versus Huawei is a landmark case. The Supreme Court case has been very important to set a new era for a new Britain. And I still like to congratulate the courts for the hard work they have been doing in this matter. I would not like to see my researchers anyway criticizing the United Kingdom or its courts or government. I'd more like to say that there were perhaps just some stuff which the court had no chance to think about because the parties did not advance the argument. In particular, the whole matter around the valuation of intellectual property remained completely unaddressed in the Supreme Court decision. It is also rather hard to introduce new evidence at the level that a case has reached the Supreme Court decision, because, well, then you cannot really start calculating around a completely new way. So I think what I have been trying to achieve with that paper is not to say this is all rubbish. What I've been trying to say is, look, there's maybe some stuff you haven't thought about, and we'd like to give you the opportunity to raise your course of action, because we have some new insights which hopefully are of interest to you. I thought the paper is of relevance not only to the current reform going on in the United Kingdom, but also to the parallel work happening in Brussels, in Washington, in Japan, and in China. And we thought, well, maybe it gives some new food for thought. Unright Planet versus Huawei, just to recap for those who do not know the case, but I think most do, just to be on the safe side, it was quite a hassle and dispute about patents that Ericsson passed on to Unright Planet to pursue licensing rates from their key competitors in the industry. I tend to think, to what extent that type of action actually constitutes any type of anti-competitive behavior has never been examined. It would be very interesting to do so, how that affects actually the market dynamics between various large corporations operating in the same space. What we saw in the case was that obviously this was the first case really in Europe where a serious FRAND valuation has been undertaken. And for that reason, I adopted the United Kingdom's Unright Planet versus Huawei approach in determining a FRAND rate, not necessarily because I agree with it or disagree, more just for reasons of practicality. There was an arm and a leg spent on determining that rate. With the budget that I had no chance of doing something completely new and from the scratch. The only thing that I did was that I made some adjustments to the existing valuation to determine a statement of the relationship between the value of the injunction and the value of the patents that led to the injunction. So that was my only very modest contribution to the world. And so what we did was we mainly retrieved the existing valuation approach and then looked at the value of the patents that were actually causing the infringement and gave way and justified the injunction. So by background, we had as key patents, we had EP744 and EP818. These patents were found in the UK both valid and infringed. Interestingly, EP744 was not found to be infringed in Germany. They pertain to LT and UMTS. What I thought was a particular spark was that EP818 actually expired 3 months after the judgment in October 2020, nonetheless gave way to a permanent injunction. One wonders. So these patents, after technical trials, were found the reason or the motivation for issuing the injunction. And so it was really the value of EP744 and EP818 that I determined and that I then put in relationship to the value of the injunction. To determine the value of the injunction, that was pretty cheap because I was stated in the judgment as being about 1% of Huawei's market share, so that you can easily figure out what that roughly is. That's not a huge step. The more tricky part was to figure out the value of EP744 and EP818 and kind of like take a slight detour from a portfolio valuation and just make the value of 2 patents in England and Wales explicit. That was what we really did. So I don't think this will create a lot of debate and discussion on the valuation side because we did not reinvent the wheel really. And the result that we found is that there's quite a significant mismatch between the value of the injunction and the value of the patents that led to the injunction. The value of EP744 would be, per the court's own thinking, around 0.0319% for handsets and 0.008% for infrastructure. And the hypothetical implied rate of EP818 would be 0.0319% for handsets and 0.008% for infrastructure in expressed in net sales, if you put that relationship to the value of the injunctions, which was 1%, you kind of like see this is quite a huge mismatch. I don't dare to say we have been able to prove hold up, or we have been able to fully prove the proportionality. We have just, all I'm saying is I'm seeing here a mismatch. Now, does mismatch start by 0.5% or 75? I would have difficulties to say that, but you're really speaking here of 0.0 something percentages in comparison to 1%. And that's for me quite a significant mismatch. And now, where I think one could incite the debate based on this analysis are different directions. The first direction is clearly the question of policy formulation. But I think also there's another huge debate around that economic assessments is insufficiently still included in legal arguments, and that's a huge shame, because it is through another discipline that one can better come to grips to what is lawful and what is fair and what meets all the goals and aspirations that a courtroom wants to set itself in being just and doing the right thing. And if you're just looking at the question through one single lens, which is the mere legal lens and not the economic lens, you may just miss out on a wealth of other insights that you're able to generate to live up to the aspiration of justice. And I think there's definitely more work that needs to be done and more awareness raising to include economic thinking in legal matters. Now, the second part, which I think is for me personally of interest and of relevance, is the question of criteria according to which one comes to the decision whether to issue an injunction or not. When we were in the case, Anwar Huawei made the point of saying that they object the injunction on the grounds that it is disproportional, but it failed to offer any type of economic substantiation of why it thinks it is disproportional. What Huawei put forward in the case was that it said, look, in the United States, we have eBay versus Merck exchange. We have a regime in place where there are criteria that help determine whether to issue an injunction or not. And we're extremely concerned that if this regime is being ignored, here in this case, then what will happen is that we will attract more NPEs, more patent assertion entities into the country, and that this will lead to hold up, that is unreasonable licensing requests from SEPS owners, and this will not be FRAND. This was the argument Huawei made. It failed to offer more meat to this argument, in my opinion, and that argument was killed. That the court said, look, guys, this is a FRAND rate, and this is a court-determined FRAND rate. If we are not doing it, it will lead to the other drama, which is hold out. That is, you can basically chase up your licensing rates, so we don't take your point. Now, what I think where this argument may have been incomplete is, first of all, why did we have to travel all the way to the United States? I spoke with my legal friends in the UK, and well, there's also wonderful research around a judgment from 1895, the Shelfer versus City of London decision, where we actually introduced already in the 19th century proportionality considerations for the issuance of an injunction. Now, I was told that's outdated. You hear this in law school, it never pops up again. You can't really make the case of Shelfer versus City of London. On the other hand side, in HTC versus Nokia, Lord Justice Arnold used the argument brought forward in Shelfer versus City of London by thinking very hard whether to issue an injunction in that case, and by looking whether that injunction would be proportional or not. And Lord Justice Arnold found at the time that it was okay, because in that instance, the infringer had a chance to implement, to invent around the patent, to sort of like navigate around it. So he said, that's okay. But the catch with standard essential patents is that navigating around them is rather hard, because once you have been implementing a standard, it's kind of like not, if it's a successful standard, there are a lot of standards which are just like patents, sit the shelf and are never sit on the shelf and are never being used. But successful standards, you cannot just undo them and you cannot invent around them. You're basically stuck with that standard. So that argument that Richard Arnold used in that instance would not fly here. Another issue that we are fighting for is also that we're fighting with, or we have no good answer yet, is the question of multi-component products. At the moment, I think patent law needs to, at the same time as we need to look back at history and 19th century cases, I also think we need to look into the 21st century and start to think what we can do really to reinvent patent law and make it commensurate with where technology and the future is heading. And we currently have the situation where in several industries which are showing double-digit growth rates around software, around the IoT, around artificial intelligence, all sorts of crazy next generation tech, are really driven by many patents that read on the same product, and not just one patent, one product, one product situation. And we currently have no good answer to how to handle that if one single patent, which may not even be super important to the whole product, but you still can't get rid of it because it reads on a standard, leads to an injunction of the entire product. And my personal take is that the Shelfer versus City of London situation could offer a good basis. We don't need to travel to the United States for these insights. That was my personal take, but my legal friends said, well, this is not how it's done at the moment. I said, well, then let's change it. Another point that I think that's important to make here is, can we think beyond hold up and hold out and start thinking really how to come to grips with licensing rates which are rooted in the economic worth of the intellectual property, rather than are rooted in a discourse that was established decades ago and which has sort of like framed our thinking and we can't step out of it. Let's try to be a bit more creative about that. So with all of that, what I think maybe it's of interest to just recap how we came to our conclusion. So we quickly looked, as Maurits very nicely explained, how they figured out the valuations. So they looked first at the comparable licensing approach. So they looked at the licensing rates that Unright Planet had been able to obtain for this patent portfolio in the past. And then they also looked at general licensing rates they could find in the industry or through other judgments. Maybe that approach is a bit limited by the fact that there's not perfect market transparency. These licensing agreements are concluded under NDA, so we don't have a lot of insights of what's really happening in the market. One may debate the exclusion of the Samsung licensing agreement, as Maurits stated, but that's what the court decided upon. And then the court was concerned with the issue of royalty stacking and ran a double check if that was actually what they were thinking of was realistic or would completely kill the business. And the way for this, they used for both methods the patent counting technique, because the court thought anything else is just too complicated and too futuristic. Let's stick to simply counting patents, SEPS declarations, and families. The two parties obviously had a very different opinion on how many patents read on the standards, and the court simply took the number in the middle. And this then helped determine the patent strength argument used in the top-down approach, and it helped also determine the share that possibly Unright Planet's patents had in the overarching standard. And then they made a differentiation by the markets, by major markets and other markets, and they adjusted it in that way. And of course, they had to adjust between handsets and infrastructure, multi-mode devices, geographic distribution, etc. And based on that extremely extensive assessments, they came then So these were the comparable licensing rates they had figured out for 2G, 2G, 3G, 2G, 3G, 4G. They used the Ericsson rate, they looked at the benchmark rate, and they obviously applied the strength ratio based simply on pattern counting. They did the same thing for infrastructure patents, which are not multimode. And they also determined the question here for the comparables. Then the next step was the share for the handsets and the share for the S share for handsets and infrastructure, again per standard. And then finally they came up with the implied total royalty burden, which is the top-down approach, where they looked if the share and the total implied burden would be doable, and the court found yes. Then there came the differentiation between the markets. UK was considered the major market for all standards. And based on this lengthy cooking recipe, they finally figured out the unwide planet rate for the major markets, which you find here for both the handsets and the infrastructure. Yeah, and here was finally the figure. These were the FRAND rates the court proposed, and which it asked to be respected under the risk of having to issue an injunction. I talked about these two patents, geographic coverage in both instances, global. And now what we then did is we really just made a few adjustments, because in the end, it wasn't like the global patent portfolio that justified the injunction, but that basically justified the injunction was only justified by 744818 patent in England and Wales. And then we came up with our estimates here. It's not perfect, but roughly speaking, that's where we hit it. And we think this is a starting point. There's more work that needs to be done to understand better what other questions we can ask into SEPs rather than hold up and hold out, how we can reinvent the discussion. I also think it invites people to think more creatively. We're currently already looking with big eyes at the question of valuing standard essential patents. So I think it's this is the first paper that has ever made the effort of valuing an injunction and set it in a relationship to the patents. And I just wonder how big the gap needs to get between patents and injunctions until the community is motivated enough to start thinking along new avenues to find new solutions to the question. Yeah, thank you. Jane, you are unmuted. You need to unmute yourself.
Sorry, I muted. Yeah, thank you very much, Roya, for that in-depth view and for your really creative suggestions of different approaches to the valuation issue. I think there are a few more questions,
yes, there are 5 questions
in the Q&A, which is great. And just I think
3 of Nigel felt very inspired to ask a question. And okay, there's an anonymous question who says, would it be appropriate for an external body to check the validity of patents in a SEP pool, considering the patent rights granted by the sovereign state and act in rem? Would it not undermine the national patent system?
So I think if I may say a word here, I think the word validity here is not meaning validity in terms of whether the patent is novel and inventive, more whether the patent does have a place in that pool with regard to that standard, which goes to both Roya's points on the valuation.
And there's a question for Nigel Worth.
I think we already answered that first question, right?
Okay.
At least I tried.
Okay,
Yeah.
then there's a second one. Would it be possible to develop an algorithmic approach to the incremental benefit of the IP held so to achieve judgment-neutral consistency and possibly alleviate international sovereign state variations.
So I have some thoughts on that if you want me to.
Yes.
So I think the two questions are related, if I understand them correctly, but maybe Nigel will want to explain them. But so the next best alternative, and it should also be the next best alternative on an ex-ante basis before the standard was set. And sometimes there's actually direct evidence of this. For instance, in connection with 3G and 4G telecommunication standards, there were direct statements about this before those standards were set, including statements by Ericsson itself. So let's take them at a level. There's a document from ETSI from 1999 called The Way Forward. And it describes that there were 5 alternatives considered for 3G technologies. And they were all more or less equally good, and they were competitive. So they were alternatives, and ETSI had to pick one. And eventually they kind of converged on one of those. But the fact that there were 5 alternatives, which were more or less equally good, and there wasn't actually a direct auction where they kind of auctioned off which one would include in the patent, but there were qualitative descriptions in the document and in the surrounding documents that indicated that these 5 alternatives were more or less equally good. So an incremental value of the one that was chosen over the next best alternative from those 4 others, you can actually make, you can look at that, those documents at the time and probably come to the conclusion that the incremental value may or may not have been less than what is currently being asked for 3G and 4G technology. You also had Ericsson's and others' own statements at the time of what the total royalty stack should be. That is a fair and reasonable royalty stack, which should be and they use things like single digit and around 7% and something like that. And then you can distribute that amongst the various patent owners and calculate a royalty per patent, and then give royalties depending on how large the portfolio is of each of the various patent owners. So that is then you can argue about whether some patents are worth more than others, which is not easy. But so you can look at direct evidence in some cases to do this kind of analysis. And then if you don't have that kind of direct analysis, then economists can entertain you for hours about hedonic pricing and potentially even on Shapley value analysis. And I will leave those to Roya, but there are indeed ways of looking at what consumers are willing to pay for an incremental functionality in a particular product compared to other products which do not have that particular functionality. It requires a regression analysis, it requires data, but there are situations where that kind of information is available, and so you can calculate the incremental value. I hope that answers the 2 questions. There may have been additional questions in the meantime.
Yeah, maybe I'd like to add something. Nigel, I hope you're still around. I don't think you can ever resolve the state of international politics through an algorithm. I wish. I have worked way too long in international politics, and you will never have a global patent or a global patent enforcement or a global patent understanding of valuation, because the interests and needs of countries across the world are just too different, and the requirements they have in the patent system are just really not the same. And the question will always remain, on which level will you set the standard? Will you set the American standard, the EU one, the British one, the one from Africa? So this is just a no-go. Even if you had the best algorithm, this is just never going to happen. I also don't think we'll ever have global harmonization of courts. No way. I wonder how this is going to work out under the Unified Patent Court. How they will figure out that harmonization and what relationship the United Kingdom will develop in relation to the UPC. So I just don't see that in any way happening. I think the decision is in and by itself an extremely interesting approach to the global governance of innovation, because it is trying to come to grips with a very old dilemma about the the tensions between national patent law and international business requirements. I mean, we have tried to crack it for ages and we're not getting there. We have the WTO system come up to try to fix this with the TRIPS agreement, which was not really doing it so far. I'm sorry, we're trying to go there, but we're not getting there. WIPO did a slightly better job, at least with global patent protection and eventually the EPO for Europe. With the Patent Cooperation Treaty, at least we have a global one-stop shop for patent protection. When it comes to patent enforcement, we are not there. So the British approach has, in my opinion, certain colonial touches to it, perhaps explained by its history. I can say that as an Austrian. Sorry, Jay.
No, sorry. I thought you were drawing to close. I just want you mentioned the World Trade Organization, which I think, and the TRIPS agreement, and perhaps that, because as you say, there's a huge conflict between the national and the global. What about the WIPO and the WIPO arbitration service? Do you think those have a bigger role to play in solving the kind of global?
No. I believe the UN system would have to be much stronger to assume such a role, having worked for the United Nations.
Fine. Thank you. I think Moritz wants to answer Eric's question, which was...
Should we read it? We are not there a bunch more. Oh, yeah. Okay, so what did Eric... So Eric Stasik, from what I have seen, Eric, correct me if I'm wrong, you have done quite some work for SEPS owners. But if I misinterpreted, let me know. So what are you writing? Is it not equally plausible that comparable licenses are infected by holdout and do not represent the true FRAND rate? Eric's would, of course, not have been incentivized to fragment their SEPS portfolio if they had been receiving a FRAND rate in the first instance.
So my reaction to that is twofold. On the one hand, yes, it is plausible that some of the comparable licenses were infected by holdout. Plausible in the sense that it is possible. And the one agreement that was excluded was the Samsung license, I understand. And if I recall correctly, it was excluded because it looked a bit like a fire sale. So that's not necessarily a holdout, but it results in a degree of power on the part of the licensee, and that's what you are concerned about. All I was saying is that if you exclude that one because there is an asymmetry in the power, then you should also exclude the other ones where the license was signed under threat of injunction, because there too there's an asymmetry of power. So I was calling for consistency. Now you say Ericsson would not have been incentivized to fragment their patent portfolio if they had received a FRAND rate in the first place. I can't speak for Ericsson. I think you probably can, because I know, if my memory serves, you worked with them. But the companies sometimes have incentives to monetize their patent portfolios to the maximum, and if that includes opportunities to extract more than a FRAND rate, that temptation is often implemented in reality. And the interesting thing is that a portfolio has diminishing returns. If you have a portfolio of 10,000 patents, then to have another 200 patents doesn't really add to the value of that portfolio. But taking those 2,100 patents out of the portfolio, therefore also doesn't diminish the value of the portfolio. And suddenly you can monetize those 200 patents separately. So it's very tempting. And some of these companies, let's leave them unnamed, had a program where they would split off 5 of these portfolios a year in order to monetize them. That to me looks like privateering. And that results in a Cournot problem, in a collective action problem, because each of those patent portfolios was sold off to different privateers. Those privateers would set the rate at the maximum that the market would bear, regardless of what others were asking. And if others are also asking whatever the market can bear, you get a royalty stack that exceeds an economic efficient total. And that's, the old Mr. Cournot in the 200 years ago already figured this out. And it's a collective action problem, because as a result, the total stack exceeds the economic efficient, and that actually hurts everybody. So that's why pooling and creating a single pool and a single portfolio for an entire patent is efficient. That's the background of my thinking. So I do not think that if Ericsson had received a FRAND rate, they would no longer have had the incentive to fragment their portfolio. That incentive and that temptation would still exist.
Thank you, Maurits. Says
Yeah,
Eric Stasik.
No, I
Yes.
healthy. Eric, you wrote a fantastic article about about licensing, and I think it's already 15 years ago, which I think was very, very interesting. So I hope you don't mind disagreeing, but there it is.
It remains a problematic field. I have not seen anyone. It remains a problematic field with opportunism all over the place.
And inevitably, organisations will use the system that's available for market advantage.
So, but Nigel says, with the wisdom we all deliver unravels many strands. I tend to think that's a good ending. Are there any further questions or comments or additional contribution?
I think we have exhausted people's patience.
Good. Well, then I hope you found it interesting. I had a good time and you have a lovely weekend. We are back in mid-December. We have a webinar on IP management with Professor Kranstrand, whom I'm terribly pronouncing with a German accent and not with a Swedish one, who will look at the interplay of IP and open innovation. And I'm super excited about it. Please join us again for that. And Maurits and Jane, thank you very, very much for the 1-year collaboration and work, and for the great output we had, and for this event today. Jane, up to you for the finishing words.
Okay, well, thank you, Roya. Thank you both. Really interesting to hear you present your papers and present some fascinating arguments and some pointers forward. So from Maurits to use, for the UK courts at least, to use competition law more, and Roya for your suggestions on using a more economic methods of valuation as well. And I think, you know, you've highlighted some of the really important issues between a single patent and the whole portfolio, and the extra market power that's given to organisations when their patents become part of a pool. So thank you very much. I hope this stimulated more debate, and look forward to ongoing discussions, and thank you.
Thank you very much. Have a nice weekend. Join us mid-December on IP management and open innovation.
Thank you, Roya. Thank you.
Bye-bye.
Bye, everyone.